distinguished guests. Are we all here? We are all here, okay. So much has been said about Sunanda and Murli, then it would be just pointless for me to repeat it. It is true that I was one of Murli Bhandari's students at the Government Law School, Bombay, as we knew it. But the truth of the matter is that I hardly ever attended his classes. And I think that's partly the reason why he was so fond of me, because I would enter the classroom late. And even though I say it myself, I was young and beautiful, and he was totally distracted. So I think that's part of the reason why he had a lifelong affection for me, as I did for him. But it is also true that I knew him as a member of the Indian National Congress. I also occasionally visited him at the office of the Indian National Congress, which was situated at what we in Bombay call the Agast Kranti Maidan. And it is also true that I was aware of the legacy which he carried with him as a lawyer, as an activist, and as somebody who was working for the trade union movement as well, as was his father-in-law, Mr. Gokhale, the late Mr. Gokhale. And since I was also working in the labor courts, arguing cases on behalf of the working class, obviously we had a bond which went beyond the classroom, government law classroom. But let me come back to the classroom. And I was thrown out of Government Law College for want of attendance. And it was Murli Bhandari who took a fight with the principal of the college and said, "Don't throw this girl out." But the principal insisted. He said, "No, rules are rules, and we can't have her in this college." So obviously, I promptly went and joined Siddharth Law College, which was founded by Dr. Ambedkar. And lo and behold, when the results of the exams were declared, I got a first class. So Murli Bhandari then went to the principal of the school and said, "Look, I told you, I warned you not to throw this girl out, and you threw her out. And what have you done? You've lost a first class for your college," because that year, nobody in Government Law College got a first class. So, I would like to say that all learning in law happens outside the law college. So, and history has repeatedly proved this. History has repeatedly proved this. There are very, very eminent people in the world who are called, quote unquote, dropouts, though I don't call myself a dropout. This being said, there was a mention of the word legacy by the learned Chief Justice of the Delhi High Court. I would like to present to you my understanding of what is legacy, and through the children of the Bhandari family. So the young lady who has been anchoring this program, Shreya Sangal, sitting here right in front of you, what is it that triggered her to go to court and get the now famous Shreya Sangal judgment? It was the fact that two young women were thought to be arrested for simply saying, "Why should the state of Maharashtra shut down when Bal Thackeray dies?" She asked this question to her grandfather, your grandfather, and I think your grandmother was alive at that time. No, she wasn't. So there was a heated conversation in the household over this issue, and she was irritating. So ultimately she was told, "Well, if you are so upset by two young women getting arrested, do something about it." And the next thing she did is she came back with a petition drafted when she was not yet a lawyer. And the petition got filed, and the rest is history. All of you know the Shreya Sangal case. That is legacy. Those were the values which her grandparents passed on to her. And The other thing was, yes, it is truly the meaning of the word legacy. The values of the Indian freedom movement are the only legacy that we can carry forward in this country and nothing else. And she did that. Then we come to another grandchild, the young lady who presented the award to the collective, to the madam. You've been presented an award by a very distinguished person. And she, at the age of 14, was given a prize, which was very substantial for her age, almost 11 lakhs. And she was asked by her parents, what do you want to do with this money? And she said, give it to the slum dwellers who are living next door. That is legacy. Those are the values that the family has carried forward. And now I'm going to move on to saying what I want to say. I think the Chief Justice of India has very clearly told us what is constitutionalism as distinguished from a constitutional text. And so I need not really repeat all of that. But just a few words. When I was asked to do this lecture, I was requested by Namita to make sure that I focus my talk on the rights of women. And she actually wanted me to say something about gender in the title of this lecture. And I said, no, Namita, I'm going to call it India's modern constitutionalism. I do call myself a feminist lawyer, but there can be no feminism without constitutionalism, and no constitutionalism without feminism. They are bound to each other like twins. And therefore, to even begin to talk about women without constitutionalism would be a bit of a poor joke. And so I decided to stick to my own subject. Constitutionalism does impose limitations on state power. That's what it really is. In its dealing with its citizens, endowed them with fundamental rights, which the state cannot violate. Today, we notice that there is a demand to put an end to constitutionalism. And the demand, in no uncertain terms, is why do we need codification? Somehow the debate is revolving around the issue of codification. And the demand is, why have a code? Custom, practice, usage is enough. Custom, practice, and usage we've had in this country for centuries, and that is what governs us. I will talk about that a little later, but this is just to illustrate what exactly is the demand that is there in the country today. As the Chief Justice said, this subject is of contemporary relevance to us. Now, the judiciary, of course, is meant to be the guardian of these rights that we possess. And I think it's time to do a reckoning. Have they really been the guardians of the rights which have been endowed to us by the Constitution? The other implication of constitutionalism is that the Constitution is a binding norm. Today, we are told, let's treat the Constitution as mere guidelines. We don't need to treat it as a binding norm. So we need to remind ourselves that constitutionalism means that the Constitution is a binding norm, binding on our citizens, binding also on those who hold positions of constitutional power. It's also a call to accountability to citizens in their interaction with each other, as also of state organs. Of course, we all know what the Constitution promises. It promises justice, social, economic, and political. It promises economic justice in its directive principles, all of which I will not read out to you, but they're supposed to be binding on, in the matter of lawmaking. We must ask ourselves the question that Martha Nussbaum would have asked, does the Constitution adequately address the question of the suffering and compassion? And do we fully share that responsibility for such suffering as being a human species? Among all sentient beings, we humans alone have free will and the capability of making change, the change that we wish to see. And therefore, we must take complete responsibility for building the nation we wish to see. The Constitution addresses itself to future generations, to the young global citizens of our times, and not to those who wish to return to power structures of centuries gone by. It is a break from the past. I believe in the clean slate theory. I believe that Indian society was governed by rigid hierarchies of caste, on the top of which were the Brahmins, who had the God-given right to ordain kings. However, as a powerful counterculture to Brahmanism, we also had atheistic traditions, such as Buddhism, which emerged, advocating equality and rejecting the rigid caste hierarchies. It emphasized the universality of suffering and promoted the idea that all individuals, regardless of caste, had the potential to attain enlightenment. Buddhism challenged the foundational principles of caste-based citizenship, discrimination. When you come to colonial rule, it reinforced exclusions in relation to caste, gender, and religion. On these lines, the Constitution not only reflects this sharp break from centuries of oppression and also from colonial rule, it is normative in its content, and it entrenches a vision of a modern society, the society that the Chief Justice spoke about, based on an egalitarian political and social order. It promotes scientific and rational thought. In all walks of life, faith and belief are not the basis of lawmaking, but at the same time, the right to freedom of conscience and religion is protected for all persons under the Constitution of India. This shared vision, which emerged from the freedom movement, is what our Constitution is based on. The movements against British rule, of course, were led, as we all know, by Gandhi and Nehru, which demanded equality and self-determination for Indians and ultimately secured independence. India chose self-determination by declaring itself a republic, shaping the national identity and committing to a mission beyond independence. The fructification of this movement is what we see in the Constitution of India, the supreme lex. All of you know the Objectives Revolution, which was introduced in the Constituent Assembly, so I won't bother you by reading it, except to once again point out, as did the Chief Justice, that we drew from the legacy of revolutions which went before our own, the French Revolution, the American Revolution, and that is why I chose to title this speech as India's modern constitutionalism. By the time the Constitution came to be framed, the Objectives Resolution was already agreed upon, and I will have a few words to say to you about recent comments that have been made about the original, quote-unquote, original Constitution. I read recently that the Honorable Vice President of India said that we must circulate for our children, quote-unquote, the original Constitution. So what is the original Constitution is the question. He seems to think it is the copy of the Constitution which has several illustrations, of which there are 3 copies, 2 being in Parliament, 1 in the Supreme Court. But those illustrations came to be done in the year 1954. It is not the original Constitution. The original Constitution doesn't have any of those illustrations, and his comment was, we must circulate this so that children know that the original Constitution of India had illustrations of Ram in it. So this is not only misinformation, but it would be interesting, as I did when I researched this paper, to have a look at what is the original Constitution. It was introduced on the floor of Parliament, and it came into force with immediate effect on 26 November 1949. And some provisions came into force. They were the provisions relating to citizenship, the provisions relating to a provisional parliament, the provision relating to the president's oath. And the rest of the provisions came into force on, as we all know, on 26 January 1950. So what will we call the original constitution? That is something that I think we need to educate ourselves about. I come back to this clean state theory. India ceased to be a colony, as we all know, in 1947. And through the process of self-determination and the freedom movement, we became a republic. What came into existence, we must remember, is a successor state, which is sui generis. The Constitution of India is sui generis. And as I will inform you later, I would like to mention a little later, that no successor state is bound by the laws of the previous state. It is up to us to write on that clean slate. And we wrote what we wanted to write on the clean slate when we adopted this constitution. Change happens, formal and informal change happens, and the only question is, what is the direction of the change? The Supreme Court of India has, however, told us that there are certain basic features of the Constitution which cannot be altered, and these include inter alia, democracy, the rule of law, secularism, federalism, judicial review, separation of powers, supremacy of the Constitution, independence of the judiciary, and republicanism. Here also a little aside that might help some of you to recall your own history. Sometime in 1999, attempts were made to quote-unquote review the Constitution by the Vajpayee government. And at that time, the President of India was Mr. Narayanan. And he was given, of course, a speech to read, which had the words, "My government will review the Constitution," close quote. And in conformity with constitutional convention and norms, the President Narayanan read out that speech as it was given to him. A few days later, he himself, while speaking at the 50th anniversary of the Constitution, said that he could not understand what was meant by the word review the Constitution. And instead, he pointed attention, he quoted Dr. Rajendra Prasad, the first president of India, who said we must find out not whether the Constitution has let us down, but whether we let the Constitution down. And taking note of his comments, the terms of the then government of the day, led by PM Vajpayee, decided not to go for a review of the Constitution, but instead, if you read the notification which set up the Venkatachalaya Committee, you will find that it says the commission is to review the functioning of the Constitution, not to review the Constitution. And through that means, by that one speech, Dr. Narayan put a halt to the process of throwing the Constitution out of the window. So again, I think those who are in positions of power today need to be reminded of their own history, so to say. The Constitution, of course, apart from guaranteeing fraternity, equality, liberty, also rejects the notion that the end justifies the means. That is something India's Constitution does not believe in. And this is entrenched in Article 21 of the Constitution of India, which says, no person shall be deprived of life or liberty, save and except according to procedure established by law. So that procedure established by law is the means to the end, which is supposedly to be received. And the Supreme Court has, of course, said that that procedure has to be just, fair, and reasonable. I'm delighted to see in the audience Rajiv Dhawan, You must all read his brief book on the Indian Constitution, published way back in 2015. Surely it's time for him to revise his book. But what is important about that is not the title of the book. We can all give our books the title, The Constitution of India. What is interesting about that book is the subheading of that. And the subheading, correct me if I'm wrong, is Miracle, Surrender, Hope. And when I first looked at the title, I said, oh my, why is he talking about miracles? And then I said, after reading the book, I said to myself, if I were to subtitle this book, I would call it Magic instead of Miracle. That is the making of the Constitution of India, a miracle, a piece of magic. He calls it surrender because it has within it the elements of a police state, if I've understood it correctly. And then we come to the question of hope. Hope, I think, he finds residing in civil society, and so do I. So I can only appeal to him to 10 years on, whether he would still call the Indian Constitution Miracle, Surrender, Hope, or might want to change the subtitle to something else. So, coming back to the Constitution, we, of course, gave up the chains of servitude. It was a means of individual liberation as also collective liberation. And we cannot forget that the Constitution called upon us to take our place, rightful place, amidst the nations of the world. And that is how we came to be a very respected member of the United Nations because of this modern constitution of ours. So just to recapitulate so that we don't miss out on the teleological mission of the Constitution of India, I'd like to quote from a judgment of the Supreme Court in the Sabarimala case. Here's the quote, open inverted commas, reading Dr. Ambedkar compels us to look at the other side of independence. I don't have time today to give you those statistics, but the other side of independence doesn't look too good to me. Besides the struggle for independence from British rule, there was another struggle going on since centuries, and which still continues. That was the struggle has been for social emancipation. It's a struggle that the Kerala Women's Collective has carried forward in resisting sexual harassment at the workplace. It has been the struggle for the replacement of an unequal social order. It has been a fight for undoing historical injustices and for righting fundamental wrongs with fundamental rights. The Constitution of India is the end product of both these struggles. It is the foundational document, which is the text and spirit, aims at a social transformation, namely the creation and preservation of an equal social order. The Constitution represents the aspirations of those who were denied the basic ingredients of a dignified existence. These words are written in the year 2022, if I'm not mistaken, and they ring true today. So the journey for social reform, and by the way, these words were written in a petition which called for an end to a practice which denied women of menstruating age between 10 and 50 from entering a temple. And it is in that context that these words were written. The journey for social, you'll find a lot of the judgments of the Supreme Court that we now call transformative have come in relation to women and transgender and abandoning binary sexuality. These are the driving forces of the new Constitution of India. Women are the driving force of the new Constitution of India. The theory for social reform, of course, we all know that this journey began very long back, and the Supreme Court has, of course, helped us on this journey for women of all communities. Mary Roy got her right to inheritance, equal inheritance, through a judgment of the Supreme Court of India in her fight against her brother, where she challenged a law which said only 5,000 rupees will be given to the daughter and the rest of the estate will go to the son. She won her case in the Supreme Court of India. Incidentally, Mrs. Bhagwati is here. Justice Bhagwati was one of the authors of that judgment. Yeah. There's another story about him, which I'll tell you later. If I start telling you stories now, I'll never finish this. So then, of course, you had the Saira Banu case, where the constitutionality of triple talaq was challenged and upheld. And it was Justice Rohington Nariman who, in my opinion, the only one of the 5 judges who made a breakthrough in that case by challenging head-on personal laws, which very few judges have had the courage to do. Yeah. So much was said about Article 15, 16. 16 was referred to as affirmative action. I prefer to call it the right to reservations. Unique in the world. Of course, now we have reservations for women in Parliament, which has not yet come into force. And I've often been asked this question, that whether I agree with it. And after much thought, I had to say, yes, I agree with it. And the reason for that is because I looked at the experience of Rwanda, which had 50% reservation for women in their constitution. But if you look at Rwanda today, it has 60% women in their assembly. So this is the power that can be unleashed by reservations. We, of course, have to deal with religion, but as I said, faith and belief cannot be the basis of lawmaking. They're nevertheless protected under Article 25 and 26 of the Constitution of India in the private domain. There is complete freedom. The liberty, people forget that the opening words are freedom of conscience. They focus only on the religion part of it. So it's conferred on individuals. And therefore, in my opinion, it has no place in public life. In my opinion, the rationale for the secularism that India adopted is that it is the only guarantee for a society that will give us the security and integrity of India. Without that, we are in danger of seeing civil wars of hatred from within the country and creating the perfect context for an external attack. So when we defend secularism, we don't do it only of quote-unquote appeasing the Muslim community. We do it in the interest of India. We are not a theocratic state. Yes, we do it because by protecting secularism, protect the integrity and security of India. We are, of course, not a theocratic state. And concomitantly, we do not have any offense known as blasphemy in this country. There is a long history. I'd like to just summarize it by saying the rule of law did not begin with the Constitution of India. It ironically did begin under Controllian rule through the 3 criminal laws that came in: the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act, all of which date back to the 19th century, enacted by the British colonizers. But what did these laws do? They gave us equality in the matter of criminal law. It's true, we didn't have equality in the matter of administration and politics, but they did bring in equality in the matter of criminal law. And to that extent, they were the forerunner of Article 21, that is, no person shall be deprived of life or liberty except by procedure established by law. So to badmouth these laws and to say, well, they are colonial, it defies logic. Crime and punishment were uniform, regardless of caste in the community to which people belonged. Unlike in the pre-colonial era, where a crime against a Brahmin was not even a crime. And there were no doubt laws like the Criminal Tribes Act of 1871, which criminalized whole communities, including transgender communities. That definitely is a vestige of colonialism. One cannot ignore that. Homophobia was institutionalized by colonial laws. Let's talk about marital rape, introduced by colonial laws. And through the doctrine of coverture, no doubt, and where a woman was supposed to experience civil death on marriage, she had no rights. She had to be represented by her husband, and therefore, why bother to ask her for consent to sex? And ironically, today we are told that the 3 new laws that have come in have decolonized these laws. Remember, they have retained the marital exception. And attempts to argue that these laws are unconstitutional are met by the government in affidavits saying that they do not wish to, that they are not unconstitutional. And that's for another day when the battle unfolds in the courtroom. So then we come to the question, what exactly is decolonization? Whether these laws have decolonized as they claim to decolonize. Of course, decolonization for us should mean taking away the colonial, but these laws do not take away the colonial. It takes me back to what Rajiv Dhawan refers to as surrender. These laws, in fact, ask us to surrender to a police state and reinforce the existence of a police state. We are told that these laws are quote-unquote Swadeshi. Now here I'm quoting Swadeshi. We are told that these laws put an Indian soul to the justice system, close quote. Now, somewhere they've also said that these, yes, while referring to sedition, we are told that these laws do not criminalize Deshadrohi, but they criminalize, and there's a word for it, but I'll come to that in a minute, but they do not criminalize Rajdrohi, they criminalize Deshadrohi. So Deshadrohi, of course, I don't see the difference between the two. I think they need a linguist to train them in language. They need to get out of these linguistic gymnastics. As far as the Indian citizen is concerned, they can find themselves behind bars for having committed offenses under the new avatar of Section 124A. And although the same offenses do exist under the Unlawful Activities Prevention Act, so one wonders how judges will navigate this landmine of having 2 offenses, one under the UAPA and one under the new criminal law, which replaces the IPC, that is 152, endangering sovereignty, unity, and integrity of India. So much for language. So obviously, in my opinion, decolonization does not mean change of language. It means something much, much deeper. When you come to how these laws are applied, they're also very differentially applied to marginalized communities as compared to the holders of power. I read somewhere that the new Delhi government also has at least 5 of their ministers who have a criminal record. So, and they talk about us having criminal records. So you can see there the impunity against prosecution that is available to power holders. And I'm just wondering, after listening to the Chief Justice of India, whether constitutionalism survives in India. Of course, we have the Supreme Court also, who has referred in the Satyendra Kumar judgment as stating that India's investigating agencies have a colonial mindset. Those are the exact words in the judgment. And in the same judgment, the government was requested to pass a new law relating to bail, the answer to which came back to court was saying, no, there's no need for bail, we have the new criminal laws. So this is the trajectory of lawmaking in modern times, and we need to ask ourselves the question whether this is decolonialization as is being offered to us. On the question of marital rape, Manali, just remind me of the time. Yeah. On the question of marital rape, and it is my view that marriage is a partnership of equals. And, what surprises me is that those who say that the Indian constitution is colonial are also the people approaching a court of law saying marital rape should not be decriminalized. The same set of people, the same ideology. They're also the people who say that India's constitution is colonial. So this confluence of interests between men, and mind you, they're all men, the people who are arguing that marital rape should not be decriminalized. And they're also the men who are saying the constitution is colonial. And they're also saying that there should be no same-sex marriage. So abortion continues to be a crime under the new laws. Let's talk a little bit about the patriarchy that persists in the judiciary. I'm going to read an extract from a judgment of the Gujarat High Court. When approached by a minor for an abortion, this is what the judge said, quote, because we are living in the 21st century, ask your mother or your grandmother. 14 to 15-year-olds is the maximum age for getting married. A child used to give birth before the age of 17. Girls get mature before boys, 4 to 5 months. Here and there, doesn't make any difference. You will not read it, but please go and read the Manusmriti at least once in your lifetime. Close quote. This is a judge. This is not me. I need to remind the audience that Dr. Ambedkar rejected the Manusmriti on the 25th of December 1927. The day when he burned the Manusmriti is also known as Stri Mukti Divas. It is celebrated all over India as Stri Mukti Divas. Of course, they've forgotten to reintroduce non-consensual sex between men, and I read somewhere a statement that we will bring it in one of these days. All this is the colonial mindset, and they owe us an explanation what they mean when they say that they're decolonizing. There are even more gross. I would say that constitutional values are under siege in the country today. The modern constitution is under siege. What I'm witnessing is something that I would call a kind of repudiation of the Constitution of India itself by those responsible for upholding it. This is done in many ways, formal and informal. The formal way to do is, we all know, is the amendment to the Citizenship Act, which allows fast-track citizenship for certain religious communities, not for others, anti-conversion laws, which go by the name of love jihad. The justification for which is love jihad. These are the formal laws that have been introduced all over the country. And while all this is happening, let's look a little bit at the status of Muslims in the country. A recent report by Christopher Jaffelot informs us that the status of Muslims in the northern part of India has dramatically declined in terms of education, fallen from 14% to 12% over the last 10 years. Employment opportunities have shrunk. Housing is not available. In the south, in Kerala and Tamil Nadu, there are better social indicators for the status of Muslims in the country. The Templeton Global report makes the point that secularizing countries where human rights are respected are able to survive as democracies rather than others where secularism is not protected. Massive inequality is seen in India. We know that the number of billionaires has increased. I will not burden this lecture with figures, but anybody who cares to read the statistics. Okay, by the way, there's been no census of India. I think the regular census which is done, we still don't see it on the table, so it's very difficult to even think of what is what is scientifically true and what is not scientifically true. A friend of mine recently told me that scientists in India are now being ridiculed because although they're the best in the world, they're saying, well, but we are told that you had a device on the moon in the Vedic age, so what are you? Are you scientists or are you something else? So finally, I would like to say that what we are witnessing is an effort to place a norm above the grund norm. And this norm is justified in the name of decolonization, and it goes by the name of cultural nationalism. Nobody, of course, bothers to tell us what culture really is, or which is this culture that is sought to be reclaimed. And it's a bit tragic that we've had, former Chief Justices of India who have said that the Dhwaja is the symbol of justice. Is it the symbol of justice? For me, the symbol of justice was always the Constitution of India. I have never entered a courtroom without taking a copy of the Constitution with me in my hand, ever. It has been my sword and my shield, the only tool that I have had with me on this journey of over 50 years. So the reinterpretation of laws to align with majoritarian ideologies threatens secularism in a multi-religious country, and hence the unity and the integrity of India is also threatened of its people, and the unity and integrity of the state itself is threatened. This is evident in recent instances where secularism and democracy have been undermined through legislative and judicial practices. Some of the judicial practices I have mentioned, but one of the most recent ones, of course, is a speech by Justice Shekhar Yadav, who is still a sitting judge, who indulged in what I consider to be hate speech within the premises of one of India's hallowed and biggest high courts. Independence of the judiciary appears to be threatened when recommendations made by the collegium are not respected. And Parliament, this is the undermining of institutions. Parliament is also undermined when criminal laws are passed as money bills to avoid the Rajya Sabha. In the executive, we find people saying that Ram is my idea of India. I beg to disagree. Ram is not my idea of India. The Constitution is my idea of India. We are told, of course, that the Constitution ignores the civilizational values of the past. This, of course, raises the question, what is the past? As I said, we worked on a clean slate. And we entrenched the values that we entrench. The discourse advocated for a return to a supposed civilization part, apart from being unsupported by any scholarly work, defining the past is also unsupported by legal theory. We know, and it is not even explicitly spelt out. It is given to us in a cloak and dagger manner. If we are told that, look here, the Indian project is the project to overthrow the Constitution of India, we will deal with it. We will protect the Constitution of India. We are here to do it. We know how to do it. But to talk in half sentences, to make suggestions without having the courage to say what they want to say, is the wisdom or lack of wisdom of cowards. The truth is, you can never have a Hindu Rashtra under a secular constitution. Of course, the day you decide to do without it, we will deal with it when that day comes. There's no need for me to deal with it today. I would, of course, like to point attention to Article 13 of the Constitution of India, which says all laws in force immediately before the commencement of this Constitution, to the extent of inconsistency with the Constitution, will remain void. I already mentioned that the judiciary has been reluctant to render void laws, personal laws, which continued in force after the Constitution came into force, but that's not my fault. I can tell you I've made the effort. And the only judge who came close to doing it was Justice Rohinton Nariman in the Saira Banu judgment, where he did say that these laws are unconstitutional. They were manifestly arbitrary. I would like to point out, of course, that there is great resistance to what is going on officially from what Mr. Dhawan called Hope constituency. And we are the ones who represent the Hope constituency. And although, of course, we are labeled as urban Nakshals and terrorists, we've also been told that we are bullying judges, but I have yet to see a judge who has been bullied. Can you enlighten me, please, whether you've seen a judge who has ever been bullied by a lawyer? No judge that I know has ever been bullied by a lawyer, regardless of what we say inside or outside the courtroom. Now, why is this happening? And this is what I will conclude with. Why is it that the Constitution is not being formally amended? Why not? I think the reason is that, well, if you can do from the back door what you need to do from the front door, why bother? You can just repudiate the Constitution in your day-to-day practice and then say that what we really need is a nation governed without codified laws. As the Chief Justice of the Delhi High Court pointed out, Constitution is the only thing that will guarantee our rights and nothing else, and that does mean a text which is normative and a text which will guarantee our rights and impose limits on the powers of the state. The Constitution is being ignored, despite all talk of constitutional transformation. The silent change is difficult to challenge. Written codes are much easier to challenge in a court. Ultimately, we are seeing the Constitution being ruled by those who ought to defend it as nothing more than a kavach, and we are seeing kartavya replace adhikar. We see judges looking for divine guidance to make their decisions. This is all very anti-constitutional. I'm going to end by saying that I stand here before you to affirm the Constitution of India. Thank you very much.